Hello, everyone, and welcome back to the Rebuttal podcast, where we break down case law, calamity, and chaos in the legal field. I am once again your host, Reb Maisel, and today we have very timely, very on point, very current event-y stuff to discuss, okay? If you have been living under a rock for the last week, you might be unaware of the present Kendrick Lamar versus Drake rap beef, rancid beef going on right now, okay? I didn't know that they were beefing so hard until I saw it all over my page on TikTok, and obviously because I'm a legal research girly, you know what I mean? I love going down a rabbit hole. I love a Wikipedia moment. I got buried. I got buried because I was like, let me not do all of the work that I have that's time sensitive. Let me figure out why these two people are beefing. And my God, to have someone in a rap battle say, you're trying to strike a chord and it's probably a minor is crazy. Certified pedophile. That's a crazy bar. Kendrick Lamar has literally won a Pulitzer Prize. In 2017, he won. He's the only rapper to ever do that, ever gotten close to doing that, okay? It's insanity. Of course, he has a legal team out the ass. And of course, right, he's aware. I think he's pretty smart, to be honest, that anything that he blatantly says as a direct accusation, he better say it and be pretty sure about it if he doesn't want to get hit with some crazy, legal dispute, defamation type label type thing. And his attorneys said yes to this. And he calls Drake a certified pedophile, which is so fucking funny. It's not funny. It's great. It's horrible, right? But God, if Drake is actually a pedophile, this is how we should probably do it. Extreme, massive public humiliation and dropping off the face of the earth. That's all I can hope for. So this all happened last week, okay? From the time that this episode was recorded, meaning all of the beef came to a head last week with a bunch of diss tracks that both sides were dropping, okay? A few days, when I say a few days, I mean literally 3 days after, okay, the last drop, the last diss track dropped, a Texas Court of Appeals case, an opinion, was filed and certified for publication talking about whether admitting rap videos during the guilt phase of a trial to show the defendant's character and sophistication were prejudicial. These cases don't come out all the time. It's not extremely niche, but it's niche enough that it's pretty unlikely that at this exact fucking time period, a Court of Appeals opinion would come out talking about this issue. Appellate courts, state appellate courts specifically, this one's in Texas, obviously, have huge dockets, okay? The appeals, notices of appeal are filed all the fucking time, hundreds upon hundreds of cases every year, okay, that they have to consider and decide and whatever, okay? The whole appeal process can take several years, quite literally. You could file the notice in 2017 and not get an opinion until 2019. It's one of those things, okay? Crazy. Wow, this is too on the nose. This is too good. This is too coincidental for me to not cover it immediately. What I'm doing different about this episode too is I haven't read this opinion, okay? I love a blind read, but from the excerpts that I saw, clips of on Twitter or whatever, I feel like this is a really good one, and I'm excited to dress it down for y'all. And we learn together, the reading rainbow, if you will, okay? In this case, which is called Larry Jean Hart versus the state of Texas, the appellant is the now convicted person, okay? He was convicted. I'm not sure if it was for murder. We will find out very soon. He was convicted in a jury trial and sent to prison, and so he's appealing that conviction based on the ground that the trial court abused its discretion by admitting rap videos during the guilt phase of trial to show the defendant's character and sophistication because the prejudice outweighed any probative value that evidence could have had. But first, for a little intro for y'all, okay? I'm reading from an article published April 2nd, 2024, so very timely, by Bridget Lavender and Matthew Segal called Rap on Trial in the State Court Report. Can singing or writing violent song lyrics be used as evidence that a person has committed a violent crime? Well, over and over again in state courts across the country, prosecutors are trying to do just that. The question for courts, including in a recent case in Iowa, is whether this tactic risks convicting people not because of what they did or didn't do, but because of how jurors react to their taste in music. It's important to note that not all musical genres have the attention of prosecutors. No, they do not. They aren't trying to prove that defendants at some point sang along to or wrote country lyrics comparable to Johnny Cash singing, quote, "I shot a man in Reno just to watch him die," end quote. Or rock songs like Freddie Mercury's lyrical confession, quote, that he just killed a man, put a gun against his head, pulled my trigger, now he's dead. Or pop hits like Taylor Swift's song, "No Body, No Crime," where she sings about murdering her friend's husband. Oh no. Instead, in case after case, when prosecutors introduce music as evidence, it's rap music. One study identified almost 700 cases since the late 1980s where rap lyrics have been used as evidence, usually against criminal defendants. For instance, in the highly publicized trial of the rapper Young Thug in Georgia, the court allowed 17 sets of the rapper's lyrics into evidence. A California appellate court is currently considering the same issue in People v. Sullivan, in which 6 rap videos and 12 pages of rap lyrics were used at trial. Last month, the Iowa Supreme Court considered the admissibility of rap music in State v. Kennedy, in which the defendant was convicted of involuntary manslaughter following a deadly shooting outside a bar. Lawrence Kennedy had initiated a fistfight with the victim, Martez Harrison. A friend of Kennedy's, Dwight Evans, shot Harrison while Kennedy was punching him. At trial, the prosecution offered and the judge allowed a video showing Kennedy and Evans rapping along to a diss track by a Chicago rap group. Although neither Kennedy nor Evans had written the track, the prosecution argued that it was relevant because one of the names in the lyrics sounded like Harrison's alleged nickname. Stares at the audience, right? You can already tell why there are First Amendment issues coming into play here, okay? Kennedy appealed, and the case eventually reached the Iowa Supreme Court. The American Civil Liberties Union, as well as the ACLU of Iowa, submitted an amicus brief arguing that rap is an art form that relies on hyperbole, not a factual account of violent conduct. No shit. And that admitting the video into evidence unfairly prejudiced Kennedy, which I agree with. But the Iowa Supreme Court acknowledged that in cases not involving the peculiar facts of Kennedy's case, other courts have expressed concerns about the risk that a jury will find that, quote, someone committed a particular act of violence because that person rapped about acts of violence, end quote, which should not and are not evidence that you would do such a thing. I, on my way to court to argue on behalf of a client, have rapped the most obscene lyrics about running drugs and getting bitches, okay, and RICO charges. Does that mean I'm a RICO? I'm going to catch one? Hopefully not, okay? Hopefully they missed my hand, but be serious. To address these risks, the court went on, some decisions, quote, have insisted on evidence tying the rap music to the specific circumstances of the charged crime. Others have concluded that rap music should be excluded when the link to the defendant or charged crime is attenuated. It's so distant, okay? This link is that you're reaching. For at least 3 reasons, courts are right to be wary of allowing this evidence. First, rap and hip hop are ubiquitous, and treating someone's enjoyment of those genres as though it carries some evidentiary value is likely to have an undue impact on criminal trials, particularly trials of people of color. Rap is arguably the most popular genre in the United States and across the world. Hip hop is a music genre and cultural movement born out of the South Bronx in the 1970s. It is inextricably connected to Black Americans and Black culture. Rap music, the musical element of hip hop, is a sophisticated and poetic art form. Second, rap is not journalism. It relies on exaggeration, hyperbole, and clever manipulation of language. As University of Georgia School of Law's Andrea Dennis has explained, rap lyrics consist of constructed images, metaphor, braggadocio, or exaggerated storylines. For example, in 1992, rapper Ice-T's rap metal band Body Count released Cop Killer, with lyrics about murdering police officers and protesting police brutality. But Ice-T has made clear that he is singing in the first person as a character who is fed up with police brutality. More recently, in her hit song Kill Bill, SZA sings about murdering her ex-boyfriend and his new girlfriend. But the murders are fictional. Clearly, the song alludes to the Quentin Tarantino film of the same name. Third, using rap lyrics in criminal trials risks undermining free speech protections, which I think is one of the most important reasons why we need to keep the shit out of court. Music and lyrical expression, including rap music and lyrics, are protected by the U.S. Constitution and state constitutions, which are often interpreted to provide stronger protection than the First Amendment. Further, allowing rap lyric evidence in criminal trials creates a high risk of unfair prejudice in a defendant's case because it can trigger negative stereotypes about rap or about Black people. Social science research shows that juries are more likely to form negative perceptions of defendants who are associated with rap music, which sucks. In one study, researcher Carrie Freed asked participants to read a set of violent lyrics taken from a 1960 folk song and falsely told them that the lyrics were either from a rap song or a country song, okay? She split them up and said rap country. I'm lying to both y'all, okay? The participants who were told that the lyrics were from a rap song were significantly more likely to say that the song was offensive, dangerous, likely to incite violence, and in need of regulation. In 2016, researchers from the University of California, Irvine replicated Freed's experiment and findings. In a 2018 study, two of those same researchers found that people who read the same set of lyrics were more likely to assume that the songwriter was involved in gang or criminal activity when they were told that the lyrics were from a rap song rather than a country or heavy metal song, despite the fact that the lyrics were exactly the same and contained the same violent or innuendo language, despite the fact that the lyrics were exactly the same and contained the same allusions, descriptions of violence, etc. Okay? It's unsurprising, really, but it's just annoying, okay? And another reason why, in order to account for society's and jurors' biases that they might not even realize they have, the courts have to step in, the law has to step in to close the gap, okay? To essentially not let this shit be valued as evidence against someone when it's so obvious that it can sway the vote one way or the other, even though it's not a literal just depiction of or even mildly related to what that person's being accused of doing. Ultimately, artists across many genres invoke violence, from Quentin Tarantino to Stephen King, without having their art used against them. Rap songs should be no different. So, with that foundation, let's get into the case of Larry Jean Hart versus the state of Texas. This opinion is literally from May 8th, 2024. On June 21st, 2017, appellant Larry Hart drove an acquaintance who he claimed he only knew by the nickname Mondo, also referred to as Little Partner or Little Mon, and three other individuals unknown to him to an apartment complex in Dallas where an individual named Michael Gardner lived. As of the day of his ultimate trial, the identity of the other passengers in appellant's vehicle were unknown. Appellant testified that he remained in the car with his four-way flashers on while the passengers robbed Michael Gardner and shot him to death. However, surveillance video from a parking lot behind Gardner's apartment shows 4 people entering Gardner's apartment. Further, a 911 caller said 4 people were running from the apartment. The state charged appellant with capital murder while committing or attempting to commit the felony offense of burglary. According to appellant's statements to police and at trial, when appellant was at an apartment complex visiting his godbrother, Mondo asked appellant for the ride and told appellant that they were going to break into Mondo's uncle's house. Although appellant was unable to explain another reason for the trip, he denied believing Mondo that the 4 were going to, quote, break into the apartment. So he was like, they probably won't. They probably won't. Appellant's theory at trial largely comported with his initial statements to law enforcement, that he gave a ride to some individuals who were relatively unknown to him as a favor, but had no idea the group planned to commit a robbery or murder. Appellant testified at trial again to this effect. When appellant's counsel began to ask whether the fact he called one of the other passengers, quote, little partner, meant he had a close relationship with him, appellant answered, quote, no, sir, I just use certain words. Like, I just have certain meanings for a lot of words. I mean, I don't have, I guess, the right comprehension skills to just, refer to somebody as the right thing because I was always just around just how I say words or just the people I'm around or it rolls out of me. Yes, sir. The court then excused the jury to conduct a competency evaluation. Dr. Lisa Clayton, who evaluated appellant, found that appellant was competent but had a low IQ. Defense counsel requested to call Dr. Clayton as a witness before the jury, but the court denied the request. As an offer of proof, however, Dr. Clayton was allowed to testify before the court as to the following. 1. Appellant has a below average IQ in the range of 70 to 80. 2. An IQ of 55 to 65 is considered an intellectual disability. 3. Due to appellant's IQ and history, he would be more likely to seek approval from others. 4. Appellant's IQ makes him naive and unable to think abstractly about motives or consequences. And 5. When appellant is under stress, he might freeze or be unable to remember things. The jury never heard Dr. Clayton's conclusions regarding appellant's diminished IQ, and appellant continued his testimony. So essentially, this testimony was only provided to the court, meaning the judge and everyone else in the room. The jury did not hear that. He told the jury that he only knew Mondo by his nickname. Oh, and also, the reason for that is because the judge made that call. Okay? I'm just saying that it happened. If you want me to get into every single decision and I'm not going to do a whole argument, objection, Your Honor, in court for y'all to every decision this judge makes. We'll let the opinion speak for itself. Okay? Because that was what the trial court judge was doing. Okay? This is now on appeal. So the appellate justices are summarizing the events that they think are relevant. Okay? And it probably may likely be that it becomes very relevant to their analysis. Hopefully. Appellant told the jury that he only knew Mondo by his nickname. He didn't see him very often. He couldn't remember what he was thinking about giving him a ride, but he was unaware he was giving Mondo a ride to commit a crime. He testified that he learned a burglary and murder happened about 24 hours later and, quote, it made him feel like real dumb. It made him feel it wasn't right. End quote. When appellant's testimony on direct examination concluded, the state moved to introduce character evidence or evidence of his level of sophistication through YouTube rap videos, quote, relating to his ability to understand what people are communicating to him and form his own opinions about things, end quote. The first video does not depict appellant, but is a picture of 3 cartoon cough syrup bottles affixed with cartoon faces of the 3 wise monkeys. The photo also depicts the name of the song IWT, I Won't Tell, and appellant's rap name, Block de Foo Foo. The second rap video the state sought to introduce depicts appellant amongst a crowd inside a house. The crowd is dancing and singing, and appellant appears to be rapping the lyrics which make references to weapons, cough syrup, and being a, quote, trap king. Appellant's attorneys, of course, objected on the grounds of relevance. Literally, correct. Nice work, guys. Okay, absolutely. This isn't fucking relevant to what, him singing a song. What does that have to do with him driving people to a house and having the motive to burgle and kill somebody? What the fuck? They objected on the grounds of relevance that the state never proved appellant wrote the lyrics. But even if he had, in my mind, okay, I'm both sides. I'm playing both sides here. Even if he had written the lyrics, that doesn't mean shit. It's hyperbole. How long it took him to come up with the lyrics, or if the voice is appellant, since appellant appears to be lip syncing in the video. Oh, I would have lost my shit. I would have lost my fucking mind. He also objected that, quote, this song is a glorification of criminal activity, including guns and drugs and violence. And in a case like this, its prejudicial effect would be quite significant. Its prejudicial effect significantly outweighs its probative value. In response, the court, the judge, noted that appellant, quote, certainly brought his character into question based on his testimony. The trial court overruled all of appellant's objections because, quote, the defendant testified as to him being friendly, which opened the door to character witness evidence in addition to the rest of his testimony. Defense counsel then requested that Dr. Clayton be allowed to testify given that the state was putting on evidence of cognitive ability, which is a good response, right? Okay, then yeah, you want to have chat about his cognitive ability, his character? Put that chick on the stand again and have her talk, okay? What the fuck? The jury still hasn't heard her say, yeah, no, his IQ is devastatingly low. You know what I mean? All this is entirely relevant to how, easily he is persuaded. Of course. How impressionable he is, naive he is. Of course. The trial court, however, never ruled on that request in the record, and the issue does not appear within the record again. Ugh. The state then pursued the following line of questioning to admit the videos. Question: are you a rapper, Mr. Hart? Answer: I mean, I do rap, but that's just a hobby I have. I write lyrics, that's it. Question: do you currently have 2 rap videos? Answer: yes, ma'am. Question: and one of those is called I Won't Tell? Answer: yes, ma'am. Question: and the other one is called The Dirty Dusty. Is that right? Answer: no, that's the artist. The trial court admitted both videos over appellant's objections, and the state continued its cross-examination. Question, Mr. Hart, what is the meaning of I won't tell? What are you referring to? Answer, I mean, this song. I mean, I have no reason, no meaning to that. It's just, I like to rap. It's question. Okay, could you possibly be referring to this case? You won't tell? Answer, no, ma'am. Question, okay, it's just convenient that it matches up? Answer, it's just a song, ma'am. Period. It's just a song, ma'am. As far as the second rap video, appellant testified that the other rapper in the video, quote, he totally wrote my version for me, end quote. He denied holding cough syrup and stated that they were empty bottles the group, quote, wrapped labels on. Moreover, he emphasized he doesn't own any guns. But even if he did, right? Like, are y'all listening to this and losing your minds like I am? Because I'm losing my fucking mind. Okay, I'm losing my fucking mind. When asked what it means to be a, quote, trap king, appellant responded, quote, you probably hear of Gucci Mane, Jay-Z. And I know you have heard of these guys because they're mainstream artists. They talk about it all the time. The court then drops a footnote. I love this. I know one of the clerks had such a great time writing this opinion. They dropped a footnote, okay, and said, Urban Dictionary identifies trap king as an exuberant drug dealer that hones a legendary street stature. See Urban Dictionary. And then they cite a bunch of examples. 2 Chainz song, Gucci Mane, Yo Gotti, Tory Lanez, Fredo Santana, Kevin Gates. You get it. Appellant's denial of owning any guns led the state to introduce additional rap lyrics and photos, this time posted on Facebook, referencing guns. Now I'm annoyed. I'm annoyed. Those references were as follows, quote, you know I draw down, you draw attention slime. Appellant replied that the verse was a Young Thug lyric. It actually comes from the Lil Wayne and Chocolate Droppa's Kevin Hart 2016 BET Hip Hop Awards performance. So the clerk, whoever wrote this opinion for the judge, was like, actually, nobody got it right, okay? Even the appellant, okay, even the defendant in this case, was like, said it was a Young Thug lyric. Nah, it's actually Lil Wayne. And then they note, appellant likely confused the lyric with Young Thug's Draw Down, which quotes, pull up with them straps on me like Steve Urkel, which is a commonly used metaphor, but appears verbatim in Just Made a Play. The best advice I can give my lil N-word, don't get caught. Again, appellant was adamant that the verse belongs to another rapper. It does. Gucci Mane, Strippa from 2016. This is all me reading from the published court opinion. I love this job. I love the law. These are all like, thank you. Like I needed all that context. Like, thank you so much. You know what I mean? Like basically this footnote, okay, and mind you, when you read through an opinion, you're like trying to guess to see like, okay, what's going to happen at the end? You know what I mean? Like, what's the vibe? Like, we're not really at the court's actual legal analysis. They're simply summarizing what the other court did. Okay, the lower court did at trial. And you can already kind of tell what the writing on the wall is going to be. Okay, the writing is literally already on the wall because they are explaining and giving so many examples. Oh yeah, no, actually, he's probably confusing that lyric with this lyric, which appears in this lyric, but also appears in this lyric. And he probably confused that with that. And he said it was this, but it was that. Basically, emphasizing implicitly that this shit is said and rapped to and rapped about all the time. This isn't enough to put people away from, right. The court again overruled relevancy and prejudice objections from appellant over the Facebook post referencing guns. Okay. Still on cross-examination, appellant explained that the posts were either lyrics written by other people or slang that he didn't intend to imply possessing weapons. I fucking hate the prosecution in this case, man. Y'all suck. Y'all are annoying and lazy. Like, fucking prove a case, can you put on a fucking case that's meritorious? Now we're getting so outside the grounds of relevancy, like with respect to whether or not he drove these people and to this complex and knew that they were doing it to burgle someone and kill someone. Like, now you're getting so far out of bounds. They're just so fucking lazy and annoying. Fuck. The defense closed its case by calling appellant's mother to testify that appellant spent a significant amount of time in remedial courses, that he was bullied as a child, that he doesn't often understand others' intentions, and that he is eager to please people. The jury returned a guilty verdict and sentenced appellant to life without parole. On direct appeal, appellant argued the trial court erred when it introduced the rap videos, Facebook posts, his oral statement to law enforcement, and a witness's credibility opinion. He further argued the trial court erred when it excluded Dr. Clayton's testimony about appellant's intelligence. A majority of the panel upheld the trial court's ruling on the evidence, which is crazy. As to the rap videos specifically, the majority held that the rap videos were relevant to guilt or innocence and that they were a, quote, small nudge toward proving a fact of consequence, specifically appellant's ability to comprehend and to form intent regarding Mondo's plan to break into Gardner's home. I'm sorry, it's just so blatantly obvious that all of these justices are just white people. And it doesn't mean that white people aren't rappers or don't enjoy rap music, but it's just like, man, if we were having this exact same argument over Johnny Cash's songs, over a bajillion other country songs, okay, the Chicks song, Goodbye Earl, this would not, like, it's just so unserious because you know that this wouldn't be the same standard. It just wouldn't. It just wouldn't. But somehow, some way, it's always applied this way. Okay, I would bet literally I would bet a lot of money. The Court of Appeals also noted appellant's argument that introduction of the videos encouraged the jury to, quote, vilify appellant's character for cultural reasons, but held the trial court could have concluded the state's need for the evidence outweighed such considerations. So, like, you're almost getting it. Like, you're almost there. Come on. As to the potential for misleading the jury, the Court of Appeals agreed, quote, the evidence did have potential to impress the jury in some irrational, but nevertheless indelible way. Nevertheless, you're almost there. Like, you're getting some of it, and then your ending final say is just fucked. Get there, okay? Fucking, use your brains. Because nevertheless, it did not find the trial court's ruling constituted a clear abuse of discretion, significant enough to overturn the conviction, okay? So now here we are. The dissent in the Court of Appeals case, okay? So there was one justice or maybe a few who joined in this dissent, okay, who had brains. That justice is Justice Rycek, okay? Justice Rycek said no. He thought it was a clear abuse of discretion, but he was outnumbered. All right. So in his dissent, he explained, quote, gangster rap like that at issue in this case is characterized by lyric formulas, a key one of which involved fictionalized bragging about the performer's badness vis-a-vis criminal behavior. The genre often emphasizes violence in inner cities, albeit not necessarily in an accurate manner. He cites to a bunch of studies, When Music Takes the Stand, a content analysis of how courts use and misuse rap lyrics in criminal cases, rap lyrics as evidence, what can music theory tell us? Like law reviews, which cite a bunch of studies, okay? Like, we're not just theorizing, you're biased. This isn't bias. This is fact. Okay, it's fact. Justice Rycek also noted persistent bias about rap and rap artists meant that introduction of the evidence would have an enormously prejudicial effect, and because the state never proved appellant authored the lyrics to anything introduced, the rap, quote, shed no light on appellant's ability to communicate with words because they weren't his words at all. Snaps. Claps for the audience. To the dissent. Even assuming appellant wrote the lyrics to the song I Won't Tell, there was no evidence of the ease with which he wrote these lyrics, how long it took him to write them, or whether anyone assisted him. Of the lyrics introduced, this song was the least sophisticated and did not establish a connection with any fact of consequence in this case. As a result, Justice Rycek wrote, any perceived probative value was vastly outweighed by the prejudicial effect. Appellant, having lost anyway, filed a petition for discretionary review, echoing the appellate court's dissent and arguing that the court erred when it minimized the, quote, harm, bias, and prejudice injected into the trial by virtue of the rap videos and Facebook pages. We granted review. Okay, I was confused, but I'm right. Okay, so Texas, has the trial courts down here. Okay, they're called district courts, trial court, all right, the first court that you go to. Then if you want to appeal something, then it goes up to the Court of Appeal. All right. And if you want to appeal something from there, it goes up either to the Supreme Court or the Court of Criminal Appeals. But they're at the same level. Our appellant, Larry Hart, had already lost a trial and then lost the first appeal. And now he is up to the Court of Criminal Appeal, which is the Supreme Court in this situation. Okay. In this area. So what is the Supreme Court's analysis on this? Well, first, they turn to the rap videos, okay? Appellant's rap videos is this beautiful heading. Now, number one, they have to look and see what the probative value of these videos is. The initial step in using a Rule 403 balancing test is identifying the probative value of the evidence. Evidence is probative if it tends to make a fact of consequence more or less likely, okay? Keep that in your head. A fact of consequence. Is him rapping, lip syncing along in a video a fact of consequence as to whether he drove people to burgle and murder? I don't know. You decide for yourselves, but decide correctly. Moreover, the state has a need for the evidence where it would prove some consequential fact unavailable from other sources. In the instant case, appellant did not dispute the fact he drove 3 individuals to the apartment complex where the complainant lived, or that those same individuals committed a burglary of the complainant's apartment, shot him, and left him for dead. Rather, appellant contested a single fact at trial. one of great consequence to the state's case, that appellant did not understand that he was driving the group to commit a robbery and murder. The parties' opening and closing statements reflect this. The state emphasized, quote, the defendant knew. He had been in an apartment complex not far away from the victim's apartment. He knew that he and a group of people were planning to commit a crime. He knew he agreed to commit that crime. He knew they were going to go and commit burglary. They were going to steal some things, and he agreed to take 4 people to the victim's apartment complex. He agreed to sit there and wait. The prosecution, the state, relied in part on appellant's statement to the police for this proposition. In the statement, appellant told the officers that when he drove the group to the complainant's, the victim's apartment, he was told they were, quote, breaking into Mondo's uncle's house. The state also pointed out inconsistencies in appellant's testimony, that he said there were only 3 people in the car when there were actually 4, that he knew folks at his godbrother's apartment complex to carry guns but didn't see any on the night in question, that he was only going to wait in the parking lot for 5 minutes when he really waited 11, and that the other individuals didn't have anything when they can be seen carrying something on surveillance. Through surveillance footage, the state also sought to prove that appellant drove by the complainant's, the victim's vehicle in the parking lot to, quote, make sure the victim's car was there. It further introduced evidence that following the murder and his own conversations with police, appellant made internet searches on his phone for, quote, Dallas Murders 2017 and, quote, if you was driver on a murder. Okay, guys, like, total aside here. We're going to pause. Don't do that. Don't do that. Okay, your internet searches are speech and they will be found. The little clear history button doesn't really work that well when you have a police agency doing the check, okay? Amazing. The state also pointed out that appellant went back to the apartments where Mondo and the other individuals spent time, despite his earlier claim that involvement in the crime, quote, scared him to death. Finally, when one of the detectives testified, the state asked this question, quote, and if somebody knew that his friends had guns and chose to go along to commit a felony at this time of night on that particular day, looked for the car to make sure he's there, would you say that the person should have anticipated that a capital murder would result? Answer, yes. But like objection, speculation, objection, no foundation, like what? After the state rested, appellant put on his case in chief, consisting primarily of his own testimony alleging he is a nice person who does favors for others, such as giving them rides, and that he did not understand the implications behind the statements and actions of the individuals in his car. In response, the state moved to introduce the complaint of rap lyrics, alleging they were relevant as, quote, character evidence, rebutting appellant's testimony that he is a, quote, friendly person, that he is not sophisticated, and that he is not, quote, not good with literature. Wow, that he is not good with literature. According to the state, the proffered evidence, in addition to proving appellant was a, quote, bad person, relates to his ability to understand what people are communicating to him and form his own opinions about things. In response, appellant objected primarily that the videos were not actually relevant at all to sophistication and comprehension because there was no evidence appellant wrote the lyrics, was singing them as opposed to lip singing, or if he did, how long it took him to write them. This, don't you get how sometimes with the law, we just get so tangled down, we get tangled up in each other down rabbit holes that it's like, what are we even talking about anymore? You know what I mean? Like, well, he was lip syncing. Okay, so like as long as you don't actually sing along to a song, you're good. Like that, it's just everything's so stupid. The state offered no proof appellant wrote the lyrics introduced, and appellant himself testified that most of the lyrics were written for him or were lyrics borrowed from other rap artists, as noted by the clerk who's writing this opinion in a fuck ton of footnotes. As outlined above, the Supreme Court says in its opinion here, a certain piece of evidence is probative if it, quote, tends to make a fact more or less probable. Here, the song appellant did not dispute he wrote, IWT, so I won't tell, was probative of his comprehension skill. The court below, so meaning the appellate court, concluded that, quote, evidence of the appellant's ability to rap, lip sync, or post lyrics about crime is a, quote, small nudge toward proving a fact of consequence. Specifically, appellant's ability to comprehend and to form intent regarding little partner's plan to break into Gardner's home. Assuming this is correct, as the Supreme Court says, we must consider whether the value of this probative evidence is outweighed by its potential for unfair prejudice, okay? The court is basically saying here, look, we can argue about how probative all day long, but ultimately, no matter how probative something is, it can be the most important shit ever, most probative shit ever, but it could still not be let in because the prejudice is higher, okay? So the court's like, just hold my beer for a minute. Let's go to the prejudice part because let's see if it's going to outweigh any type of probative value that you're going to argue about, okay? And let's hope that they get to the right answer. Turning to the prejudicial danger factor, okay? The court addresses the potential that the other crimes, wrongs, or acts that were shown in the rap videos have to impress the jury in some irrational but nevertheless indelible way. The unfair prejudice question asks whether the evidence has a tendency to suggest decision, so verdict, on an improper basis, usually emotional in nature, okay? This is the same analysis used to exclude evidence when it might be super relevant and so spot on, but it's just inflammatory in a way that's unnecessary and in a way that is basically used simply to like stoke the emotions of the jury and get them to find a guilty verdict, basically for the wrong reasons, right? So an example would be like very, very graphic images, crime scene photos, especially if like the victim is a child, whatever. Yes, of course, like the close-ups of the injuries potentially, right? Like all of that's going to be relevant. The medical examiner will be the one to take the stand and, do all of that. In every case, it's different. But in some cases, okay, it's like sometimes the state will just want to put up every single one of the most graphic photos you've ever seen in your life, even though it really, like, it's not really relating to like whether or not this person actually did it. It's like, okay, you made your point. Like this is now becoming too prejudicial because it's going to inflame the jury in such an emotional way, and they're going to become so overwhelmed by how much horrifying content that they're seeing, regardless of who did it, right? That it's going to lead to them making potentially a decision that's based on their emotions and their anger and seeing these photos than on strictly the facts of whether this specific person did the thing that we're accusing them of doing. While Texas, the state of Texas, before May 8th, 2024, had not yet addressed this issue firmly by statute or really in like a on-point relevant case, courts in other jurisdictions have recognized that the admission of rap music or rap videos is highly prejudicial due to the nature of the lyrics that distract from the charged offense. In United States versus Bay, the Eastern District of Pennsylvania noted that lyrics in rap songs often contain inflammatory material that is entirely irrelevant to the case at hand, which risks inflaming the jurors and has no bearing whatsoever as to whether the defendant committed the offense charged. Quote, rap lyrics are not necessarily autobiographical statements. Rather, rap music is a well-recognized musical genre that often utilizes exaggeration, metaphor, braggadocio, and hyperbole for the purpose of artistic expression. Thank you. Logic, common sense here, finally being applied. In the law and the legal field, sense is not common. No, it is not. It is unusual, it is unique, it is rare. Okay, but when common sense comes in, when the sense suddenly seems to be a little more commonplace happenstance, goddamn is it beautiful. And this case is an example of one of them. Okay, that quote alone, God bless. By no means is rap the exclusive genre for glorification of criminal activity. Most song lyrics are often fictitious or exaggerations of real events. It is not reasonable to assume that all lyrics are autobiographical as to past or future content unless there is direct evidence to suggest otherwise. Basically, there has to be evidence outside of the actual fucking verse, the bars, okay, in the cipher, that you are absolutely ripping, that would prove that the verse that you're giving is totally you making a confession or saying shit that you're for sure planning to do, okay? Yes, rap lyrics are often hyperbole, exaggeration, of course. Like, you can't take them at face value for what this person does, like in their own free time, in their personal life, or what they intend to do, or criminal things that they intend to do. But also, right, you can't just set a full murder confession to a fire beat, BBL Drizzy, and suddenly, right, be good, be off. Like, there would have to be other evidence, okay, showing that whatever verse that you just hit on the beat is literally what you plan to do or did or whatever. And of course, that's so logical. Holding song lyrics to their literal meaning would lead to the following conclusions. Freddie Mercury literally killed a man. Bob Marley shot the sheriff. Macy Gray committed murder and got away. The band formerly known as the Dixie Chicks killed Earl. And classically, Johnny Cash shot a man just to watch him die. These are conclusions we cannot accept outside of some other evidence demonstrating the lyrics are something more than fiction. God bless. But for whatever reason, okay, rap lyrics, rap songs are treated differently in court and are shoved in front of juries' faces in court by prosecutors okay? Whether someone wrote it or they just lip synced along to it in a Snapchat video, all right? If their skin color is brown or black, you better believe that any association to violent rap lyrics exemplifying, talking about criminal activity, okay, thugging, whatever, you better believe the prosecution is going to try to enter that evidence in, thinking that, oh, like this is great. The jury's going to immediately be scandalized and think that this person's, a criminal, which we all know why. Okay, we all know why. But those type of biases are inherent in society, in the culture. Oftentimes, I don't think people even realize that they would attribute those things, okay? That they're literally saying, oh, well, black people in rap music, so they're criminals. What the fuck? I don't think that that's what's going on. It's these inherent biases that are implicit and are knee-jerk. We cannot depend on the general public to account for their own biases when they are in juries. God, no, okay? Sense is not common, especially not in a courtroom, right? They are not logical. The general public is a scary place. We, as lawyers, as judges in the law, need to fill in the gap, okay, that these biases are going to create inherently. We can't just assume everyone's going to be smart or logical or use common sense or not be biased as fuck, okay? So that's why rap videos and rap lyrics and rap music and all this shit, and his favorite song was about fucking bitches and getting money and running guns. Okay, and like object. We throw that evidence out. We exclude that evidence because it's irrelevant. Unless it's directly fucking relevant in some other way to the crime, to the thing that the person's accused of. Why in the frick frack paddywhack would we bring that in? Because it's only going to be prejudicial. It's only going to be unfairly prejudicial to the defendant, to the accused, in a way that really doesn't matter at the end of the day for whether or not they did the crime. Like the prosecution's just trying to get easy money, right? Because they're lazy. Per Yosh. Examples of where some other evidence was required to basically admit the rap lyric evidence, those videos, whatever, are found in pretty recent cases, okay? For example, in 2020, in a Louisiana case, the court admitted 2 rap videos, but not another one, where the admissible videos specifically described the subject of the charge and the inadmissible video did not. So basically, okay, whatever this defendant was accused of, he described it in very graphic detail in these 2 songs, like literally to a T. And it matched up pretty well with the charge. So unfortunately, right? Damn, that's crazy. Be a little bit more vague, people. All right. In a 6th Circuit case in 2007, the court found no abusive discretion in the admission of rap lyrics that described killing snitches and government witnesses, wrapping them in blankets and dumping their bodies in the street, which was literally exactly what the government accused the defendant of doing. Okay. So like, watch your mouths. Watch your mouths a little bit. If you want to do crimes, don't do them, okay? This is not legal advice, but like maybe, right, don't really match up what you're singing about perfectly with what you actually do. XOXO Gossip Girl. Here, in this case, okay, that we're talking about in Texas now, the videos introduced by the prosecution were indeed a glorification of criminal activity. The lyrics and videos included references to illicit drugs, criminal activity in general, dirty money, snitching, owning weapons, degrading women, and classically being a, quote, trap king. As discussed above, other courts have recognized that the content of these songs and videos can, however, unduly prejudice the jury to convict him on the improper basis that he is a criminal generally or associates with criminals generally simply because he likes this type of music. This is because any song that glorifies criminality, regardless of genre, is inherently prejudicial. Thank you, Texas Supreme Court. I never thought I'd say those words. The danger associated with playing these videos to the jury is that the jury might regard creative expression as proof that the defendant engaged in criminal behavior based upon his rap videos instead of regarding them as nothing more than creative expression. This is problematic in this case, in defendant's case, for 2 reasons. Now, remember, okay, our defendant in this case, right, he liked to rap. All right, he liked to rap and he did it under the name Block de Fufu. All right, Block de Fufu. When I say rap, I'm telling you like the local small town, hometown SoundCloud rappers. Okay, we all know them. We all know so many of them. Maybe get like 20, 30 views like on their stuff. Okay, but even if he got like 10,000 views, okay, cool, whatever. But like he's doing it for fun. Okay, doing it for fun. That's kind of rapper he was. And the court, unfortunately, for our boy Block de Fufu, had to point out that he was not very popular. Like he's not really famous, right? Like you're not really getting like a lot of spins. All right, which is fine, great in this case for him, for his appeal, but we'll get into it. So the court says, first, of course, the appellant, the defendant, lacked the inherent familiarity popularity of a popular artist that provides the ability to disassociate the artist with the individual. Unlike an easily recognizable pop star, the listener cannot disassociate bloc de foo-foo from the message. Bloc de foo-foo, okay, is again the kind of type of spins that would lead us to believe the jury is going to bring their sense that should be common but isn't into the courtroom to be able to do that, okay? For bloc de foo-foo, the court was like, they couldn't have done that, even if you told him to. Like, they were going to think that everything he said was attributed directly to him. Second, the subject matter in the expression is itself inflammatory. Regardless of the genre, inflammatory lyrics create the potential that the jury could ascribe character assessments to the defendant based on the content of the music he listened to or lyrics he wrote. Said plainly, music lyrics do not prove anything about the character of the person who listens to the music or lip syncs to it on video. Put that quote in the Louvre. Let's fucking go. Because remember, like, this has been going on for years and years and years, decades and decades. The whole like Satanist scare, okay, that whole panic, the Satan panic of like the 70s, 80s and shit, where people who were like, I mean, the amount of fucking young kids, people who they found have been wrongfully convicted of crazy murders that were like quote unquote satanic murders, simply because there were like the few teenagers in the town who were cool and listened to like heavy metal rock. All right. They were like, oh, that obviously means that they like demons and shit. And they introduced all the lyrics into evidence and we're like, yeah, that means they want to do all this stuff. And they went to prison for the rest of their lives. Like, that shit's crazy. They also do that same thing with fucking school shootings, which pisses me the fuck off as someone who was on campus when our school had our school shooting that ended up in the deaths of several people. When I was in college, not in law school, college. Yeah, it pisses me off to no fucking end when the Fox News type Fox and Friends media goes immediately to, oh, well, who was the shooter? Okay, well, what kind of music did he listen to? Like, did he play video? He played violent video games, and violent video games are the reason. Oh, well, violent rap is the reason. Like, that's not the reason why people commit crimes. Have you seen the most emotionally stable, kind, lovely people in the world listen to the heaviest metal, screamo shit, terrifying shit, okay, Satanist shit, and they're doing just fine and don't commit crimes? Like, it's just the most annoying cop-out, but this cop-out is not new, right? That's why that quote, right, being seen in an opinion in 2024 is great. It's not the first time we've seen that quote. I've seen a quote like that, right, where they're like, hey, music lyrics don't prove shit, several times. But like, it used to be that the general consensus and opinion of the law and the culture and society was that, oh no, lyrics for sure, the type of music you listen to can for sure indicate what kind of character you have, which is nuts. As the Texas Supreme Court says, quote, we don't convict people for murder simply because they have written lyrics about murder. We certainly wouldn't convict a person of murder for rapping about drinking, drugs, and guns. Here, the prosecution did not offer anything demonstrating that the lyrics and video were somehow representative of the defendant's character and that they applied outside of the artistic rendering, nor did they demonstrate that, even if they had some real-world application, it was relevant to the charged offense. It wasn't fucking relevant. It's stupid. So the prejudicial value, okay, the danger of prejudice, the prejudicial danger element, all right, of this evidence, the court properly found that it weighs heavily in favor of excluding the evidence, okay? Heavily. Exclude that shit. The next factor that the court considers, okay, in this analysis as to whether or not this evidence should indeed be excluded is, we've already gone through the probative value of the evidence, okay, which is pretty low, the prejudicial effect, which is high presently. The next factor is the prosecution's need for the evidence, okay? Like, did you really need it that bad? What was that? What was the vibe? And this is what they said. The prosecution's need for this evidence was weak. As discussed above, the state had several other available options to address appellant's mental state when he drove the individuals to the victim's apartment. These methods included defendant's statement that Mondo told him they were going to break into his uncle's house, inconsistencies or evasiveness in the same statement, surveillance footage of appellant pulling the car around the parking lot prior to letting the other individuals out of the car, defendant's internet search activity in the days following the murder, and the fact that the defendant subsequently visited the apartments again despite being purportedly scared to death at the time of the shooting. Right? This is all different evidence that could have basically proved the same thing for the prosecution. All right? We do this in the law all the time where we're like, okay, if this specific evidence that you were trying to put on for this purpose, okay, to show that like everything he's saying is probably wrong, okay, like you're trying to discredit him, trying to impeach him. If that evidence that you're trying to put on for that purpose is super prejudicial, highly prejudicial, sucks, okay, is going to create make this whole thing a clusterfuck, all right, of like prejudice and bias and all that with a jury, do you have other evidence that could prove the same fucking thing or be put on for the same purpose that isn't fucking inflammatory as shit and prejudicial as fuck that's going to result in a reversal of this conviction? All right. And if the prosecution says, yes, we do, then the court's going to say, okay, well, then we're not fucking putting on that goddamn evidence of the rap lyrics and videos, bitch, because you got other shit. You have other shit that could say the same thing. And this is exactly what the Supreme Court held as well. Like, hey, you could have talked about all these other things, and you did for sure. But like, why'd you talk about the thing that made this whole thing a clusterfuck, right? I'm not like super against putting this evidence on because I think that this defendant is like innocent and should have gotten off. I'm saying that if you want to put on a trial that is comporting with our constitutional rights of due process, the process better be due, okay? It better be due and done and dizzied so that we don't have, right, people sitting in jail potentially being convicted on a basis that's improper. And in this case, the prejudicial effect, in my opinion, of including the rap lyrics and videos and shit as evidence, even though you had all this other evidence that proved the same fucking thing you were trying to do, is just too prejudicial. And we shouldn't set the standard public policy wise, right? Even if this guy, yeah, maybe if he were lying, right, about whether he knew, like maybe he totally knew. Okay, maybe he totally knew. And I feel like there's a decent amount of evidence for a reasonable jury to conclude that he knew what they were going to do, right? He drove the car knowing that they were going to burgle. He ran inside. He lied about a bunch of stuff. There's inconsistencies. Like you can convict him on that, right? You shouldn't convict him on the rap lyrics because if you do that, then it sets a tone and public policy standard that we're going to apply across the board that other people are going to be convicted and probably won't have all that fucking evidence against them, potentially, right? What if they really are like innocent as fuck and the prosecution has no good evidence, so they're like, fuck it, rap lyric videos and throw it in and then they get convicted. Like that's the type of standard that we want to maintain and make sure that that shit doesn't go awry. That's why there are extreme consequences to like putting on evidence that is not fucking good. Okay, like overturning a conviction or like reversal, right? All that shit, or like mistrial, all that. Because if there weren't, then the prosecution would do it regardless. Look at cops and qualified immunity. If there are no consequences, they don't give a fuck, right? They're just going to keep doing it. So there you have it. There's my soapbox. Okay, I'm off. Okay, this evidence, all right, all the evidence that I just listed, all right, that wasn't the rap lyric videos, this evidence tended to show that the defendant was indeed aware of the circumstances surrounding the trip to the victim's apartment. So basically, like, it contradicted everything he said, you know? You could have just put on that evidence and kept it cute, but they didn't. So as a result, the court held this factor, the state's need factor, weighs heavily in favor of excluding the rap lyric evidence, okay? Heavily in favor of finding that allowing the prosecution to put on the rap lyric video evidence is obscene. Last thing the court does is weigh the factors. We're going to weigh them. Skinny, we're going to weigh them. Considering the extreme danger of prejudice resulting from the introduction of appellant's rap videos, admission of the videos was indeed error under Rule 403. Woo! Cheers from the audience. The video's probative value was incredibly weak, especially where the prosecution introduced no evidence that the appellant authored the lyrics or merely memorized them. Was he actually singing or was he lip syncing? Did he have any assistance in becoming proficient enough to perform? And how long did it take for him to be able to successfully pull off the performance? Without answers to these questions, using the video introduced in this trial was unfairly prejudicial and proved very little about his intellectual capabilities. The videos did not reflect any significant amount of credulity or articulacy. Wow. And were not relevant to appellant's character, since there was no evidence outside of the lyrics themselves corroborating that appellant was a violent or unfriendly person. In fact, the state conceded at oral argument that the mere act of lip-syncing a song, regardless of the genre, does not make one a friendly or unfriendly person. Like, the prosecutors need to fuck off. Like, they're so annoying. Like, this is why sometimes, like, egg on your face. Like, what the fuck are you saying here? You know what I mean? Like, every single specific case that you hear about, yeah, everything is so fact intensive. Like this case is so fact intensive for purposes of like, oh yeah, this defendant, his IQ and all this stuff. But like, these are the broad questions that finally in appellate court, right, all the way back up to the Supreme Court, it took long enough, need to be asking and whose job it is to ask, right? Hey, so like this is a public policy thing. Is every time someone raps a fucking lyric, okay, regardless of genre, mean they're a friendly or unfriendly person? Yes or no? Like, yes or fucking no, because that's what you're trying to say here. That's the principle. That's the hill that you're dying on currently, presently. Okay? And we are not fucking with. So finally, the Supreme Court considers the harm to the defendant, to the appellant in this case, as a result of this error. Okay? Because an important thing to note is that not all errors that trial courts make during a trial or in a decision are errors that require reversal or an overturning or whatnot, okay? Like many a time, there's an entire opinion kind of like this where they're just dog walking everything the trial court did with respect to this one issue. But in this next final stage of the analysis, they have to consider, the Court of Appeal, the Supreme Court has to consider the harm that resulted from the error to the defendant, to the appellant, okay? If the error that's found, they're like, yep, there's an error, doesn't result in a harm to the defendant that really resulted in a complete swaying of the vibes of what was already gonna happen with respect to a conviction, whatnot, okay? Or if like it's just not likely that a reasonable jury would have really been impacted so much by this error that they would have basically made a different decision, then it's considered harmless error. Okay, harmless, less of a harm. Okay, so that means that even if the Supreme Court could find, hey, yeah, the trial court totally erred. They erred. Okay, there was an error. Your conviction's upheld. Sorry, bye. The court says, having found error. Yep. In this case, we proceed to a harm analysis. Because the error in this case was an abuse of discretion in admitting certain evidence, we review the record for error affecting the defendant's substantial rights. In doing so, we review the entirety of the record to understand the evidence in the context of the trial. If the error had more than a slight influence on the verdict, the appellant, the defendant, is entitled to a new trial. Okay? Here, because the appellant, the defendant, did not contest whether he drove 4 individuals to an apartment complex whereupon they committed capital murder, the only issue at trial was his intent, his mens rea. Whether appellant knew what he was doing and should have foreseen the result, so his mental state. The prosecution focused its case on proving this mental state. In doing so, it asked law enforcement officers to give several negative credibility determinations of the appellant, which were admitted with no objection. Following the prosecution's case, appellant's case primarily consisted of his own testimony. He testified he had a hard time remembering, he is a friendly person and believed he was just giving a ride, he doesn't think critically about the words he uses, he has a hard time understanding things, and when he discovered what happened, he felt dumb. In providing additional context for appellant's conceitedly dumb actions, the appellant sought to introduce testimony from his competency hearing that revealed he has a low IQ and potentially could not understand the underlying motives of the individuals in his car on June 21st. The trial court did not permit this evidence, however. Had Dr. Clayton been allowed to testify, she would have told the jury that individuals with diminished IQ trust others easily, are more naive, don't think abstractly about the motives of others, are more forgetful when under stress, and are generally more susceptible to manipulation by others. The jury, in this sense, was not allowed to hear appellant's side of the story, despite it having heard the prosecution's full story assisted by officers' credibility determinations, okay? We're getting some weather here. Like you can kind of see where it's going. They're being like this opinion's being very critical of what went down, which hopefully I still don't know how this played out. So fingers crossed. Then came the rap videos, period. Oh my God. See, okay, maybe we do know how this is going to fucking play out because it's literally a new paragraph indent. Then came the rap videos, period. Like, buckle up. After having heard the state cast appellant as a liar, as testified to by law enforcement, who also lie a lot, listen to my episode Dirty Liars and hear all about it, and being deprived of potentially helpful testimony from Dr. Clayton, the state introduced both rap videos to demonstrate appellant was literate and articulate. As discussed above in the context of Rule 403, the Texas Rule of Evidence 403, these rap videos did very little to prove that fact and instead just cast appellant and his fellow performers as criminals in general. Fuck the prosecution, y'all are cops in suits, y'all are annoying, hate you, untethered to the particular facts of the charged offense. Moreover, while introducing the videos, the state went as far as injecting its own interpretations of slang words into appellant's testimony. Quote, and in the I Won't Tell video, you talk about killing somebody over a bill. So killing somebody over cash, is that right? Appellant, I didn't say I killed anyone, ma'am. The state, and you say you keep a heater. A heater is a gun, isn't it? Appellant, I didn't say I keep a heater on that song. Do you understand? Do you see how they're like trying to get him to say, like they're literally injecting their own interpretations of slang into the fucking testimony of appellant. And he's like, I didn't say I killed anyone, man. I didn't say I keep a heater on that song. And also it's like, you're feeding him the definition of what you think a heater is, as opposed to laying the foundation for like, hey, what's a heater? Da-da-da. Following appellant's testimony, appellant called his mother to testify to the fact that appellant was in special education classes, had a hard time remembering, and required additional care and instruction as a child. After her testimony, appellant rested. The state emphasized both appellant's mens rea and the, quote, type of criminal it proposed appellant was in its closing argument. Quote, this is not Mayberry RFD, and this guy is no Gomer Pyle. Larry Hart is criminally responsible for Michael Gardner's murder because he knew he should have anticipated what was going to happen. Larry Hart is the kind of criminal that sneaks around at night, breaks into people's apartments with a gun to their head, and leaves them for the coroner to pick up. While the prosecution argued here that appellant acted as more than a driver, much of the evidence developed at trial was that appellant served as the driver and did not enter the residence. Ooh. Had the evidence more directly implicated appellant as an active participant instead of simply a party, this might have been a closer case. However, we decline appellant's request to draw a bright line rule that all artistic expression should always be excluded from a criminal proceeding unless it is a truthful narrative of the offense. So basically, even though I've kind of just explained to you that does kind of seem like the rule that a lot of state courts have been applying, even though there isn't like a general case that we can cite to for this principle, Texas is staying its hand. It doesn't want to throw down a bright line rule that says literally all artistic expression should always be excluded. Okay, like there are circumstances and situations where this type of evidence is let in because it's literally like a line by line description confession of someone doing a crime that they ultimately did line by line. But definitely wish we had more direct clarity on this issue overall as a country. Like I do think we need it. And not have it just be state by state, who the fuck knows, okay? Therefore, ultimately, in conclusion, viewed in light of the record as a whole, okay? Not just one little factor, record as a whole, the court found that the introduction of extraneous rap videos had more than a slight effect on the jury's verdict and therefore affected appellant's substantial rights. The Supreme Court ended its opinion with a heading that says conclusion and this little paragraph right here. We think appellant stated our view on the issue at hand best when he said during the trial, quote, it's just rap, ma'am. Because the rap video is highly prejudicial in nature in the context of a guilt-innocence proceeding, appellant has shown reversible error. We reverse and remand to the trial court for a new trial. Woo! It's not that he's just getting off amazing great. It's like, no, he should get a fair fucking trial, right? The process must be due. The due must be processed. Okay? And that is the case of Hart versus the state of Texas, published May 8th, 2024. Hope you learned something about rap lyrics, a little bit of First Amendment, free speech, expression, hyperbole, etc., being used in criminal trials. Keep in mind that the way that rap is treated in contrast to country music and rap music and pop music is pretty fucked. Pretty fucked, okay? And our inherent biases should not impact whether someone gets convicted or not in such a way that where it's relying entirely on the artistic expression of people who often use exaggeration in their art. That is my rebuttal for this episode. Join us next time for a sillier, funnier episode that I am planning regarding a shark and an arm and some mafiosos. Okay? It'll be great. It'll be amazing. Love you guys. Thanks for joining. Follow everywhere. Subscribe. Leave a comment, please. Anywhere you're watching. Let me know how you feel. What are your feels? And if you're going to rap about it, be a little more vague. Love you.